Mr. President, Excellencies, distinguished participants, it is an honor and a privilege for me to welcome you from this site on the role of parliamentarians in promoting the universality of the Rome Statute. I do so with my colleague Yendu Yeong, Ambassador of the Republic of Korea to the Netherlands. Together, we co-facilitate the ASP group on promoting universality. Special words of gratitude go out to His Excellency Piotr Hofmanski, President of the Court, and to His Excellency Fabio Massimo Castaldo, Vice President of the European Parliament, for joining us today. This event has been organized by our partners, Parliamentarians for Global Actions, and I commend them for their unrelenting efforts to promote multilateralism, human rights, and the rule of law. Parliamentarians are to the heart, and they are the center of democracy and the rule of law. Also in Europe, we see now very clearly how essential that is. Universal ratification of the Rome Statute is key. So far, 123 states have committed themselves to the standards of the Rome Statute. That is 2/3 of all the states, but that is too little. And we need to work hard to get the other 33% to sign up to the court's mission and standards. For the fight against impunity, for the worst international crimes, it is of the essence that we do this with more and more states. Only together in a coalition of states, parliaments, civil society, international organizations, and all other stakeholders, we can do this. Democratically elected representatives, both of states already party to the Rome Statute and also of states that are not a party to the Rome Statute, it is important to play a key role in this regard. I will stop here and hand the floor over to my dear colleague, Ambassador Yeondu Yeong from Korea. Thank you, Mr. Chairman.
Thank you, Ambassador. Your Excellency, Ambassador and Permanent Representative of the Republic of Korea to the Netherlands as well as to the ICC, please, I give you the floor.
Thank you, Dr. Katrin. Good afternoon, Excellencies, distinguished participants. It is a great honor for me to deliver these opening remarks in my capacity as an ambassador of the Republic of Korea. I would like to express my sincere gratitude to the PGA, Parliamentarians for Global Action, for organizing this side event and inviting me, together with Ambassador Fast, to take part in this significant event. The Republic of Korea, together with the Netherlands, has actively contributed to the efforts to promote, as far as possible, the universality and full implementation of the Rome Statute by reaching out to non-state parties and encouraging their ratification of the Rome Statute from the beginning of the court. Korea is actively involved in this noble mission, as we firmly believe the wider participation of states in the Rome Statute will undoubtedly lead to stronger support for the court by reinforcing independent system of international criminal justice to fight impunity and deter the gravest crimes under international law. The universality of the system of the Rome Statute of the ICC can be achieved once all states decide to ratify or accede to the Rome Statute of the ICC. Korean economy showed a rapid advancement toward its higher status, and its economy grows. As its economy grows, people's desire and demand for a higher standard of human rights protection, care for victims who suffer from atrocities has increased more than ever. If we want people everywhere, including our population, to enjoy the same legal protection against atrocious crimes such as genocide, joining the ICC will be the most efficient system. To any country that may have doubts about joining, Korea, together with the Netherlands, is open for the communication and ready to provide support. Thank you for your attention.
Thank you very much, Your Excellency, Ambassador Yeon Do-yong. And certainly the Asia region is the least represented into the Rome Statute system, and the role that Korea is playing is really extraordinarily important. Now we have our keynote speaker of the day, and we are honored by the presence of the president of the court, Judge Piotr Ovmansky. Judge Ovmansky, you are the new president of the court, and for the first time you are addressing a meeting of the Parliamentarians for Global Action. So we are extremely grateful and proud that you decided to accept our invitation. Please, Your Excellency, the floor is yours.
Mr. Chair, Excellencies, ladies and gentlemen, I am indeed very pleased for the opportunity to address this event on the universal ratification of the Rome Statute. I would like to thank the Parliamentarians of Global Action, the Netherlands and the Republic of Korea for convening this discussion. I'm happy to say that the court and the ICC presidency in particular has a close partnership and excellent cooperation with the PGA, the Netherlands and Korea on this highly important issue. Indeed, promoting universal ratification of the Rome Statute is one of my top priorities as president of the ICC. Why does it matter so much? The main reason lies in the ICC's mission, which is to fight impunity for the gravest crime under international law, genocide, crime against humanity, war crimes, and the crime of aggression. In doing so, the ICC delivers justice to victims, including reparation, and contributes to the prevention of the future crime. This is a mandate that matters for all of humanity, and we would like to see people everywhere in the world to benefit from it. At the same time, every country that joins the Rome Statute strengthens the ICC's work by providing cooperation and support for the court. Indeed, ratification of the Rome Statute strengthens the rule of law domestically as well as internationally. In other words, joining the ICC means reducing the space for impunity at home and also everywhere else in the world. As such, ratification of the Rome Statute should be in the national interest of every state, but at the same time, it is an act that benefits humanity as a whole. For all these reasons, when I addressed the United Nations General Assembly a month ago, I placed strong emphasis to urging more states to join the Rome Statute. In my remarks, I outlined the main reasons of main benefits of joining the ICC. This includes the deterrence of future crimes, strengthening the rule of law, domesticating commitments to international law, peace, security, and human rights, and advancing the sustainable development goal 16, and gaining a seat in the ASP and the right to nominate candidates, vote in election, and take place in the decision, the future of international criminal justice. And finally, joining the ICC opens up career opportunities for the country's lawyers, as the court gives priority in recruitment to state party nationals. I also address some of the most common misunderstandings that may stand in way of ratification in some countries, such as the fact that ratification has no retroactive effect, and that the principle of complementarity means that the ICC will not try to replace the national courts of any country. I often also underline that the ICC is not a human rights court. It does not deal with the state responsibility. It prosecutes individuals only. Finally, for many countries, an important factor to be aware of is that there are no reporting requirements under the Rome Statute, which could be a burden for small states. Parliamentarians are uniquely placed to raise awareness about these important factors among the political decision makers in the national settings. Excellencies, ladies and gentlemen, it is essential that we all continue to work together to promote global support for the ICC and the universality of the Rome Statute. Even if there are no real low-hanging fruit left, there are several non-state parties which are realistic candidates for joining the ICC in the next few years. I invite all of you to use your influence and networks to join these efforts. This is not just a task for parliamentarians and diplomats from non-state parties, but also from states that are already part of the ICC system. We need state parties to actively encourage all their neighbors and friends to join the ICC system. And I urge all state parties to work through their regional organization to create opportunities for the ICC to engage more in the regional context. For instance, by proposing that your regional organization advise the ICC to brief the number states on its mandate and on its work. Dialogue is essential on the road toward universality. Finally, I would like to remind everyone that ratification of the Rome Statute is not only the only act we need to promote together. Particularly for parliamentarians, it is very important to also pay attention to the need for all state parties to implement the Rome Statute in a national law, if they have not already done so, and to ratify the agreement on the privileges and the immunities of the ICC. On that note, let me thank again for organizing this event, and I thank all those present for their attention.
Thank you, Judge Hofmansky. Mr. President, we know how busy you are with increased work in the courtroom and a lot of things happening nowadays in The Hague. So thank you for being so clear and sharp in your remarks. We start, in fact, implementing one of your suggestions to go regional. Well, you and I, we both come from a region called the European Union. And we happen to be honored today to have received a video from the Vice President of the European Parliament in charge of human rights and democracy, Mr. Fabio Massimo Castaldo. He is currently campaigning for his re-election for the third time, but so he's holding meetings as we speak, but he recorded this video this morning. If you can share the screen, and Mr. Castaldo is also the chairman of the PGA European Parliament group.
Dear ambassadors of the Netherlands and the Republic of Korea, distinguished representatives of the state parties and non-parties. Year 2021.
Is there a problem with the sound?
Okay, there's no sound.
There's no sound? Okay, then we will proceed with the program and come back to the video at a later stage, if you don't mind. We are joined by the PGA board member in charge of the ICC campaign from Kuala Lumpur, Malaysia, Honorable Kasturi Patto. She's the member of the Foreign Affairs Committee. Kasturi, I hope that you are with us. I saw you earlier. Oh.
Yes, I'm here.
Wonderful. And Malaysia has been the intense focus of many efforts towards ratification of the statute as a very democratic and vibrant state from which also prominent lawyers are coming to international jurisdiction. Honorable Patto, I would like you to maybe shed a light on the situation in your country and maybe make reference to other situations. Please kindly take the floor.
Thank you, David. The President of the ICC, ambassadors of the Netherlands and the Republic of Korea, distinguished representatives of states and non-governmental organizations, colleagues, parliamentarians, and friends from Parliamentarians for Global Action. It is my pleasure to address you today and share the experience of my country, Malaysia, regarding the ICC accession process. As you may know, Malaysia was the first, and I hope the last country that has deposited the accession instrument and subsequently withdrew it. Today, I would like to therefore provide an overview of the process that led to the accession and explore the possible ways and arguments forward to reactivate the accession process. Following a unanimous decision by the Cabinet in December 2018, Malaysia deposited its instrument of accession to the Rome Statute in March 2019. One may ask, in spite of Malaysia gaining independence in 1957 and sending Malaysian soldiers as part of the UN peacekeeping operations by the then Prime Minister Mahathir Mohamad and his deputy Datuk Sri Anwar Ibrahim, they also called on the Organization of Islamic Cooperation, OIC, in 1995 to set up measures to help the newly independent country as a concerned party to grievous human rights violations in the Bosnian War in 1993. To this day, Malaysia and Bosnia have established good relations with embassies in Sarajevo and Kuala Lumpur. Malaysia even became home for many of the Bosnian men, women, including survivors of the Serb-run concentration camps and orphans whose parents were killed in the violent murders, genocide and ethnic cleansing in Bosnia, so that they can be given a safe home in the warm, comforting arms of many Malaysian families. Malaysia became the second home to hundreds of Bosniaks 26 years ago, and this was attested by Hamza Karcik, a Bosniak who found refuge in Malaysia and now an associate professor at the Faculty of Political Science at the University of Sarajevo. One would then think the next step in seeking justice for the families of those who were persecuted was to naturally pursue bringing these war criminals to justice, utilizing existing tools and mechanisms in place to achieve that. And that mechanism was for Malaysia to ratify the Rome Statute and for the case to be referred to the International Criminal Court. However, that didn't happen. After more than 2 decades, there has been a vacuum on the discourse of the Rome Statute and the International Criminal Court. In those days where misleading information on printed press was easier to manage and apprehend, these days, the spread of false information like wildfire on social media is one of the biggest battles a lawmaker, political party, or government will face when narrating why it is important for any government to accede to the Rome Statute. Adding fire to that is the comedy or the tragedy of politics of the Rome Statute in Malaysia. For over 2 decades, the government had not been serious in acceding to the Rome Statute, and at the same time lacked the drive to create an awareness and educate the public on why it is important for a sovereign nation like Malaysia to do so. One of the false informations that did its rounds was the king will be hauled to court if Malaysia commits crimes against humanity, and a statement like that certainly triggered emotions more than logic, and the Rome Statute was kept in cold storage until someone takes it out. After Pakatan Harapan became government, after the 2018 general elections, toppling a government that had been in power from independence in 1957, one of the reforms that was aimed to take place was the ratification of international conventions and treaties, including the Rome Statute. An announcement was made that the government was acceding to the Rome Statute, and because the narrative was not set for public consumption, airspace was hijacked by parties in the opposition, namely the United Malays National Organization UMNO and the Islamic Party of Malaysia PAS, riling up the masses with fear and misinformation, and this made its way to Parliament with emotional arguments from MPs against the Rome Statute. Academicians with vested interests were summoned to brief the Council of Rulers, and their misleading arguments resulted in the Council of Rulers objecting to it. And sadly, the government withdrew from the treaty, citing the people were not ready for it in April 2019. However, with constant support of the Parliamentarians for Global Action through their numerous and various platforms to discuss the importance of ratifying the Rome Statute and a post-mortem by Malaysian lawmakers, it could be something we can crank up in 2022 and steer the conversation to the positives of the accession instead of the other way around. While there has been a lot of propaganda and misinformation regarding the ICC, many officials and voices in the country relentlessly continue to advocate for the accession. In the meantime, there are certain ways how to prepare the ground for a smoother political discussion in favor of the accession. In addition to that, with Malaysia as a newly minted member in the United Nations Human Rights Council, with a tenure from 2022 to 2024, I certainly hope that the government will be open to discussing about the Rome Statute and the ICC and why Malaysia will benefit greatly rubbing shoulders with other countries that are state party to justice, democracy, and good governance. The way forward would be, I would say, divided into 4 points. It would be advisable to first adopt the legislation implementing the Rome Statute provisions into the domestic legal order. As a result, acceding to the statute might seem more feasible and in conformity with domestic law. It would be important to also engage in public discussion explaining that the Rome Statute does not entail any inconsistency or incoherence with the Malaysian Constitution and does not erode any privilege of the rulers other than what Malaysia has already been bound by through the international treaties it is a party to, or customary international law. For instance, the Convention on the Prevention and Punishment of Crime of Genocide that Malaysia ratified in 1994 states that persons who have committed genocide shall be punished, whether they are constitutionally responsible rulers, public officials, or private individuals. As the rulers were concerned that they could be considered commanders and thus be easily held responsible of committing war crimes on the basis of the principle of command responsibility, The implementing legislation could include a provision clarifying that the principle of commander responsibility relates to a person which is in effective position of command and control, or effective authority and control. This means that the king and the rulers who are constitutional monarchs cannot fall under this characterization and would be excluded on this basis. This stems from the powers vested in the king and the conference of rulers. While in Malaysia, a parliamentary democracy with a federal constitutional monarchy, the constitution vests the nominal executive authority of the federation to the king. The king is bound to act in accordance with the advice of the cabinet, or a minister acting under the general authority of the cabinet, headed by the prime minister. The king and the rulers are bestowed with functions relating to, for example, representation, limited discretionary and advisory powers, not satisfying the threshold of effective command or authority and control. Providing examples of other monarchies where the issue of immunities had not posed an obstacle in joining the Rome Statute could definitely be very relevant. For instance, a number of kingdoms with absolute immunity provisions in their constitutions have ratified the Rome Statute, including Belgium, Denmark, the Netherlands, Norway, Spain, Sweden, the Hashemite Kingdom of Jordan, and others. It is interesting to see how they align their constitutions with the Rome Statute. For instance, in Spain, the Council of State came to the view that as all public acts done by the king have to be countersigned. It is the countersigning official and not the king who would face the individual criminal responsibility. Finally, on a broader point, as the anti-ICC propaganda has stemmed from the misinformation, relevant stakeholders such as academics, NGOs, experts should join efforts and engage in public advocacy to explain the ICC and both international and domestic benefits for Malaysia in joining the Rome Statute. There is much to gain through the accession of the Rome Statute and the International Criminal Court. We still may have a long way to go, but I'm hopeful that with more stable political situation and a lot of public discussions, we will soon join the ICC global membership. Lastly, I would like to thank David for his leadership in the PGA, the chair for PGA Malaysia, the Malaysian chapter, Honorable Kula Segren, the Malaysian Bar Council, which has also engaged on various platforms and forums, particularly on webinars on the ICC, and Frederica for their invaluable input in my sharing today. I look forward to hearing from all of you, and I thank everyone for your time. Thank you.
Thank you very much, Honorable. And you really gave us a full spectrum of remedies to the crisis that we had in 2019. I see the ambassadors noting. And let me also stress here that when we met on behalf of PGA in a delegation led by Senator Boris Dietrich 2 months ago in his office, Prosecutor Karim Khan, he expressed the willingness and interest in being part of this educational conversation with the rulers and other lawmakers, decision makers in Malaysia. So I think we have really a vast alliance to be building on, and we believe that the leadership of the Parliamentarians for Global Action Group in Malaysia will be invaluable. Let me then move to your colleague from the Commonwealth countries, because Malaysia, like Jamaica, adopted in 2012 the Commonwealth model law to implement the ICC statute. So your attorney generals already agreed on a very important document that could be a basis for domestic implementation. And today, we are honored to receive the participation of Honorable Angela Brown Burke, who is not only a prominent member of parliament, former mayor of Kingston, but she's also the leader of the opposition, as she has been recently elected the chairwoman of the People's National Party. Angela, we are absolutely delighted to have you here. It's an enormous honor, and I am grateful to give you the floor. Honorable Brown Burke, please.
Thank you very much, David. Just for clarity, I am chairwoman of the People's National Party. The leader of the party, however, is the president of the People's National Party, but that's okay. President of the ICC, Vice President of the European Parliament, ambassadors of the Netherlands and the Republic of Korea, representative of states and non-governmental organizations, colleague parliamentarians, and friends from Parliamentarians for Global Action. Good morning and good afternoon. It is a great privilege from Kingston, Jamaica, to be able to address you today at this important event taking place on the occasion of the 20th Assembly of States Parties to the Rome Statute of the ICC, an international treaty that our global parliamentary network started to promote in 1989. Thanks, of course, to the leadership of a lawmaker from the Caribbean state of Trinidad and Tobago, Mr. A.N.R. Robinson. He started his campaign for the international justice when he was a member of parliament, and then continued it through his entire career when he was prime minister and then president of the republic. You know, genocide, crimes against humanity, war crimes, and crimes of aggression all represent major threats for the peaceful coexistence among states and within states. As members of parliament, I believe we have a solemn duty to prevent conflicts and to bring about durable peace and justice in our societies. It's against this background that I think it is absolutely essential for the international community and individual states to cooperate and ensure that the most serious crimes against humanity are not ignored. Today, we are discussing the universality of the ICC, which will be achieved when all 123 sovereign member states of the international community ratify the Rome Statute. I must say that within my region, 29 of the 35 member states of the Organization of American States have joined the ICC. And this includes all South American states and the overwhelming majority of Central American, Caribbean, and North American states. Only 6 states within the OAS are not yet parties to the Rome Statute. And that would be the Bahamas, Cuba, Haiti, Nicaragua, the United States, and my own home country, Jamaica. I'm very much inspired by the willingness to strengthen cooperation with the ICC that was expressed by the Committee on Juridical and Political Affairs of the OAS during a technical meeting held in June earlier this year, where PGA was represented by one of its board members, Diputada Jimenez. As he rightfully stated, 2 main aspects must be prioritized to make this universal cooperation a reality: political will and consolidation of national legal framework. This is what needs to be done in Jamaica. In fact, while Jamaica is one of the 3 Caribbean countries among its 15 member states of CARICOM that has not yet become a state party of the Rome Statute, Parliamentarians for Global Action has worked with parliamentarians from Jamaica since 2002 on ratification and implementation, primarily to counter the negative influence on the ICC dossier from neighboring USA. And we all know that for countries like us in the Caribbean, how important the views and positions of the United States of America is. During the 2011-2016 legislature, the PGA team, working with Member of Parliament and Cabinet Minister, my former colleague, Arnaldo Brown, who served as a former Deputy Minister for Foreign Affairs, had spearheaded a process that led to the Attorney General drafting implementing legislation. Such implementing legislation was based on the revised Commonwealth model law in implementing the Rome Statute that was adopted by the Commonwealth Attorneys General and Ministers of Justice in their summit held in Sydney in 2012. However, due to other legislative priorities, the legislative process could not be finalized in that legislature. And unfortunately, after Jamaica's general elections in February 2016, the new government of Jamaica did not give priority to the legislative dossier on the implementation of the Rome Statute of the ICC. The draft implementing legislation, which had been transmitted by the executive to the legislative drafting office within Parliament, remains to be transmitted and addressed by Parliament. In Jamaica, ratification of a treaty such as the Rome Statute depends on executive decision of the cabinet, but it is an established practice that Parliament must pass the relevant legislation to domesticate the obligation deriving from the treaty in question, ahead of or in parallel with the process of ratification. As the deputy leader of opposition business in the lower house, I will certainly be calling upon the government to undertake these necessary steps. PGA will continue to engage with and support the involvement of Jamaican parliamentarians on this key issue as they have done in the past. The Speaker of the House of Representatives of Jamaica attended PGA's 10th Consultative Assembly of Parliamentarians on ICC and the rule of law in November 2018 in Kiev at the Parliament of Ukraine. At that time, the Speaker cautioned against optimism regarding the prioritization of the ICC ratification dossier in Jamaica due to the negative influence of the US position on the ICC. Now, given the change of US administration, PGA has once again started to work together with US high officials and has received renewed support from members of the US Congress on the imperative to fight impunity for the most serious international crimes and to support the ICC. I believe, therefore, that the time is ripe to push for the ratification of the Roma Statute in Jamaica, and I am certainly looking forward to working with PGA on this critical issue and promoting the universality of the Rome Statute of the International Criminal Court before my colleagues and with my colleagues. Thank you for your time and kind attention.
Thank you, Honorable Brown Burke. And in fact, we are delighted in PGA to receive your prominent leadership in the region on so many campaigns. And even now, as a candidate for our new board of 2022, we cannot but be happy of the contributions that you will continue to make. Let me just report to you that before coming here, half an hour ago, the Undersecretary for Civilian Security, Democracy and Human Rights of the US State Department, Ms. Usra Zeya, intervened in the ASP with really an unreservedly supportive intervention that we will be available on the website of the ASP, and we will share with you, because this shows how the United States now is willing to cooperate with the International Criminal Court, and action speaks louder than words. And the Biden administration not only removed the sanctions against the prosecutor from the previous administration, but even nominated and sent to the Congress the name of a very prominent jurist from Stanford University, Professor Beth Van Schaack, to be the next ambassador at large for global criminal justice, really a world prominent leader in the fight against impunity. So I think there are all the measures in place to engage with Washington and work together on new ratifications also of countries, law-abiding nations like Jamaica. This brings us to our last intervenient from a national parliament. And the country of Ukraine is certainly a country under, unfortunately, aggressive tactics and strategies from its largest neighbor, suffering from a lot of losses in the Donbass, in Crimea, and a lot of human rights violations that might be qualified as crimes against humanity. So without further ado, I'm really honored and thrilled to give the floor to the Deputy Chairperson of the Foreign Affairs Committee of the Rada of Ukraine, and also prominent member of the Servant of the People Party, Honorable Marina Bardina. Honorable Bardina, the floor is yours.
Thank you very much, and thank you for introduction, focusing attention of listeners on the right on the right events or in the right things happening in Ukraine. So, Excellencies, ladies and gentlemen, I'm grateful to the President and the Secretary General of the Parliamentarians for Global Action for inviting me to attend this event and this opportunity to share our and my personal as Ukrainian parliamentarian experience on the topic. So first and foremost, I shall begin by stating that Ukraine's path to the ratification of the Rome Statute of the ICC is still underway. However, we are as close to it today as ever in the 20 years since the moment of signature of this crucial piece of international law. A key player is undoubtedly the Ukrainian parliament, which efficiently reacts and removes any obstacles in integrating a provision of the statute into our national legislation. Yet the conclusion by the Constitutional Court of Ukraine from the year 2001 has been a major impediment and a reason for almost a 13-year delay in ratification of the Rome Statute. According to it, the founding document of the ICC was declared incompatible with the Ukrainian constitution. Therefore, a primary task since has been amending the constitution of Ukraine, and it was a success, albeit a belated one. Speaking of obstacles, in the past 8 years, the armed aggression by the Russian Federation, temporary occupation of the Autonomous Republic of Crimea and the city of Sevastopol, as well as the temporary occupation of certain territories of Donetsk and Luhansk regions of Ukraine by Russia, have been huge handicaps to ratification of the Rome Statute. Perpetrators guilty of international crimes in Crimea and Donbass cannot be left unpunished, and this is something that the international community can agree on. To expedite the process, taking into account the difficulty of amending the constitution, the Ukrainian parliament has firstly recognized the temporary jurisdiction of the ICC twice, approving in February 2014 a statement recognizing the jurisdiction of the court under Article 7 of the statute during peaceful protest between some period in Ukrainian history. Yeah? And in February 2015, a statement recognizing the jurisdiction of the court under Articles 7 and 8 of the statute regarding crimes committed by the high-ranking officials of the Russian Federation and leaders of terrorist organizations in the east of Ukraine. So by the end of June 2016, the Ukrainian parliament had finally approved the amendments to the constitution, and the law of Ukraine on amendments to the constitution of Ukraine regarding justice has been in effect since June 2019. This therefore allows the Verkhovna Rada to consider the issues of ratification of the Rome Statute. It will be possible when a corresponding law is put forward by the President of Ukraine and tabled on the agenda. So the significance of ratifying the Roma Statute for Ukraine highlights that our criminal law requires amendments too, and they must be introduced for our legislation to align with international standards better. With that, Ukrainian courts may be able to use the statute, and the issues at hand are the gravest crimes according to international law as covered by the Rome Statute, like crimes against humanity, war crimes, crimes of aggression, and genocide. Indeed, to introduce responsibility for war crimes into domestic law, a draft law on amendments to certain legislative acts of Ukraine regarding the implementation of the norms of international criminal and humanitarian law has been developed and approved by the parliament as a law in May 2021, and it now requires a signature by the president to come into effect. So without question, the ratification of Rome Statute has brought support in the Ukrainian parliament and our society. But at the same time, it is worth to noting that many oppose to process and spread malign narratives, manipulate facts, and aim to discredit and distort the role of ICC and the consequences of the ratification for Ukrainian military personnel and volunteers that are guarding state sovereignty in eastern Ukraine. I am deeply convinced that ratification of Rome Statute is sure to open new possibilities for Ukraine to utilize mechanisms of the ICC to bring those responsible for international crimes to justice. Ukraine will receive a set of rights according to the statute, not just obligations that stem from the recognition of the temporary jurisdiction of the ICC. So I hope that Ukraine will soon join the list of states parties to the Rome Statute of the International Criminal Court. So thank you for your time and your attention.
Dear Honorable Bardina, you really enlighten us on the entire spectrum of the engagement of Ukraine on this very important treaty. You reminded us that Ukraine signed more than 20 years ago the Rome Statute, and that you changed the constitution. But I think I want to emphasize one thing before to give the floor to our civil society leader in Kiev, Alexandra Mantwychuk, is that the Russian propaganda, in my view, because this comes mainly from Russia, it's so violent, sometimes it's really so direct against Ukrainian service members that I think it is really a major effort that we need to do also together with the international community. We have, for example, engaged together with our colleagues from the civil society with the EU Special Representative for Human Rights, Mr. Eamon Gilmore, who spoke with your authorities. We need really to make an effort, maybe in January, February, to really come out in public to debunk these fake news about the fact that joining the ICC for Ukraine will create a disadvantage versus Russia. The point is that if it was in the advantage of Russia for Ukraine to be in the ICC, why is that Russia didn't ratify for itself to be even more in advantage? So it's really a fake propaganda that is created at heart to create a psychological conditioning on the top leadership of Ukraine. It happened with President Poroshenko. It is happening again. And I think we need really to come out with a clear message altogether. In this respect, Honorable Bardina, I'm really delighted to give the floor to one of the leaders of the Euromaidan peaceful revolution, our dear colleague and executive director of the Center for Civil Liberty, Alexandra Mantwychuk. Alexandra, please take the floor.
Thank you very much for providing me a floor. It's an honor for me to speak on this event. A few words about context of the whole situation. Last week, Ukraine celebrated the anniversary of the Revolution of Dignity. 8 years ago, people came out against corrupt authoritarian regime and pay a pretty high price for it. When the authoritarian regime broke down, Ukraine was given the opportunity to undergo democratic transformations. And to stop Ukraine on this path, Russia occupied Crimea and launched a hybrid war in the Donbas, which resulted in numerous serious crimes, and these crimes unfortunately are still going on. As my colleague Marina Bardina told, Ukraine is not a state party to the statute. However, the government of Ukraine lodged two declarations under Article 12 of the statute, so the court may exercise jurisdiction over the Rome Statute crimes committed on the territory of Ukraine, including occupied Crimea and Donbas. On December 2020, former prosecutor Fatou Bensouda announced the conclusion of the preliminary examination of the situation in Ukraine. She states that there is a reasonable basis at this time to believe that a broad range of conduct constituting war crimes and crimes against humanity within the jurisdiction of the court have been committed from 20 February 2014 onwards. However, due to the number of factors, including existing budgetary constraints, the submitting of the request for authorization for opening of an investigation had been postponed for a year already. And this is the first problem on which I want to focus on. ICC plays an essential role in delivering justice to victims and communities affected by the most horrible crimes, especially in situation in Ukraine, where Ukraine domestic system has lack of necessary knowledge and resources to be able to effectively investigate and prosecute perpetrators. Such delay is ruined the belief in international justice. The second problem is that Ukraine is still not ratified the Rome Statute of ICC. It's an international obligation of Ukraine under Article 8 of the Association Agreement with the EU. Either ratification was hampered by 3-year postponement of the entry into force of amendments to the Constitution of Ukraine, but this term expired on June 2019. The former head of President Office announced the ratification of Rome Statute as a priority, but the Ukrainian parliament and Ukrainian government and Ukrainian president has not submitted a bill on ratification. In general, no progress was made for these years, and this is a real strange situation. And the third problem is the president of Ukraine still didn't sign the adopted by the parliament of Ukraine over 6 months ago draft IHL implementation bill 2689. The UN Human Rights Monitoring Mission applied to Ukrainian authorities and asked them to sign this law in their last report, but President's office keeps silence. It's a really strange situation when the Ukrainian president publicly declares that Ukraine will prosecute perpetrators who committed war crimes in the frame of the armed conflict, but himself make an obstacle to it. Based on this, we have 3 main recommendations. First, we call on the Assembly of State Parties to adopt a budget for the calendar next year that accommodates the Office of the Prosecutor with the resources required to open and ensure effective investigations into the situation in Ukraine, as well as respond to the legitimate expectations of the victims and communities affected by the committed crimes. Second, we call on the prosecutor, Mr. Karim Khan, to request authorization from the judges of the pretrial chamber of the court to open investigations. And third, we call on the international community to make a consistent and consolidated efforts to put pressure on Ukraine's officials, in particular the President of Ukraine, in order to ratify Rome Statute of ICC and immediately sign the draft IHL implementation bill 2689. Thank you.
Thank you very much, Alexandra. And you lead the human rights agenda, and you work with so many NGOs. I noticed that today we have also Nadia Volkova from the Ukrainian Legal Assistance Center, and our colleague Scott Martin also connected from Kiev. So it's a wonderful coalition we have in Kiev. And I think also PGA should reactivate its work with our former member Svitlana Zalechuk, who I believe occupies a very prominent position in the cabinet to move ahead with this dossier. Let me just say, Alexandra, it is not for us to ask the ASP to give the budget to the prosecutor on one or another situation. The prosecutor must be totally independent. And I understand the frustration on the ground, but it's not really the work of the ASP. But what we are advocating for is that all the money that is necessary for the budget of the court should be given to the court. And certain position of certain states should be removed from the agenda. This is a court of justice. It's not yet another international organization. So if justice demands more money, the money must be made available for the cases. It's a court of law. If in the Netherlands or in Italy, we need more money because we have a crime wave in the streets from mafia or from other organizations, we will spend more money. So if in the world there are more crimes against humanity and the court can have more cases, it has to be given more money, provided that states are unwilling or unable to bring to justice the perpetrators, because there is the principle of complementarity. Now, I think what the prosecutor said publicly regarding Ukraine is that if Ukraine would ratify, the consideration of the preliminary examination or investigation would be different in a way. That's my interpretation. Maybe I'm totally wrong, so I'm putting on the table for the debate. But I think the prosecutor here provided a stimulus to the government to come forward with the ratification. It remains really a big question mark why a law passed by more than 2/3 of the Rada in May, including all the members of PGA supporting it, including Mr. Monastyrsky, who was the chairman of the Security Committee, who is now the Minister of Interior, I believe, or Security, exactly. Why then the cabinet, why then the president didn't sign that into law? So hopefully it's just a delay, but I think out of this meeting, there is a renewed understanding that civil society, parliamentarians, authorities from the ASP should all together ask the government to implement all its previous commitments. I don't know if we want to proceed immediately with the, we fix the technical problem with the president of the European Parliament, but I see Honorable Angela Brown-Burke who wants to intervene, and that would be marvelous if she could take the floor before that we show the video, so to have more interaction.
No, I'm sorry. No, I don't. I was just listening to the conversation and finding it very interesting. Sorry about that.
Thank you so much, Honorable. Therefore, is there any comment or question or intervention relating to the three situations that we highlighted that anyone would like to put on the table? Or we want to move to the, otherwise we move to the European Parliament presentation. Yes, Ambassador van der Kwast. Please, Ambassador, unmute yourself. Your Excellency, Ambassador Henk van der Kwast, please take the floor if you can unmute yourself.
Yeah, sorry for the delay, David, but I wanted to thank the speakers very much for the insight they gave in their situations, because I think their explanations, how it works, is really, really very valuable for all of us to see how we can see to help others to work on that. So many thanks for that. Second, I wanted to agree very much with what you just said, David, on the necessary funds. Let us be very clear on that, and I think the help of PGA and other NGOs would be very, very welcome, because as you may aware, there is currently a debate in the margins of the meeting going on very few states who say it's all too expensive, we can't do this, we can't do that. And I think it would be a shame if, just having heard those stories, the court would not have the funds necessary to do their work. So I very much agree with you, first on the independence, yes indeed, but secondly, if states have to do one thing, it is stand up for justice and put their money where their mouth is. Thank you so much. I just wanted to make that point.
Thank you. And I know I want to pay a tribute here to the Netherlands, because I heard yesterday that you are funding a lot of the activities of the ASP, you and the City Hall of The Hague. So that's something that shouldn't be underestimated. It's a very well-organized assembly during these coronavirus times. Let me then turn to maybe those who could help us also to provide more funding for global civil society, which is the European Union. And Vice President Castaldo was the only male parliamentarian in the agenda, so it must be, for a matter of gender equality, he must be speaking with us. So let's try to have the audio on. Let's go. Yes.
No. Okay, just 1 second. Thank you.
ICC, Your Excellencies, dear ambassadors of the Netherlands and the Republic of Korea, distinguished representatives of the state parties and non-parties to the Rome Statute of the ICC, dear colleagues parliamentarians, and dear friends from the civil society, how can we protect and advance peace and democracy in any society when the most horrific abuses of human rights and violations of international law, from genocide to crimes against humanity to war crimes and the crime of aggression, remain unpunished, fueling a culture of impunity that impedes the construction of state institutions? This is a question we expected to be obsolete in the year 2021, but that is still dramatically placed on our daily agenda as decision makers. In fact, the recent return to power after 20 years of the Taliban's totalitarian regime in Afghanistan must also be understood as a result of the total failure of governmental structures in which justice was absent and the army was not ready to fight for a state in which impunity of leaders implicated in the perpetration of atrocity crimes as well as corruption was rampant. The case of Afghanistan proves again the lesson from history that teaches us that a successful fight against impunity for atrocity crimes is a precondition to peace, a precondition to stability, human rights, democracy, and a sustainable development in a given society. As many states, like Afghanistan between 2001 and 2021, continue to be unwilling and unable to credibly put an end to impunity, an effective and universally supported ICC is more important and relevant than ever. This is the starting point for the engagement of the European Parliament and of the European Union as a whole in the global movement for international and domestic justice against the perpetration of atrocity crimes. Since the ICC's functioning is based on the jurisdictional criteria of territoriality or nationality of the perpetrators, universality of membership will mean universality in the exercise of a jurisdiction before the ICC. The EU decision of 2011 on the ICC calls all the institutions of the EU and its member states to promote the universality of the Rome Statute system through the universal ratification of the statute and, as decided by the European Parliament in an almost unanimous resolution of 17 July 2014 on the crime of aggression launched by PGA members, that's something I'm really honored always to remember, the ratification of all its amendments. This means that the EU is firmly committed to protect the integrity of the statute, which is a guarantee for the independence and impartiality of the court. The EU is also strongly engaged in increasing the effectiveness of the Rome Statute system by ensuring that domestic legal frameworks are equipped with the tools to advance the accountability for international crimes and to provide justice to victims at the domestic level. The full implementation of the Rome Statute includes the implementation of the principle of complementarity, comprising the definitions of the crimes of the Rome Statute and the general principles of international criminal law, and the implementation of the provisions on cooperation with the ICC and the conclusions of cooperation agreements between the states and the ICC so that the ICC can fulfill its mandate. To advance these ambitious goals, it is paramount to create alliances and partnerships across continents and sectors. Bearing in mind that the ICC is a court without parliament, the European Parliament performs the vital role of a democratically elected body that supports the quest from civil society, victims, and NGOs for the equality of all before the law, and the dynamic application of international criminal law and other remedial measures to prevent and address international crimes. In this enormously difficult task, we count on the partnership with the Parliamentarians for Global Action, which has developed within its membership in 132 countries at a global parliamentary constituency for the Rome State system and the ICC. At the European Parliament, we are ready to make use of every possible avenue and opportunity of political dialogue to advance new ratification of the Rome Statute, and our cooperation is crucial to this fight. Evidence of the importance of this synergy is, for example, the joint engagement with parliamentarians from Pacific Island states within the framework of the African, Caribbean, Pacific, the so-called ACP-EU Joint Parliamentary Assembly since 2017. Thanks to the force of PGA members and the colleagues from the European Parliament, we contributed to the last ratification of the statute by Kiribati and the renewed commitment by Tuvalu to do the same. Now we must be prepared to concert our efforts and to increase our pressure on our colleagues participating in the Ukraine Parliamentary Association Committee, in the Euro-Latin American Parliamentary Assembly, the Eurolat, and the Delegation for Relations with the countries of Southeast Asia and ASEAN countries. To conclude, I would like to highlight the importance of global campaigns of civil society against impunity. These are essential to generate political endorsement and mobilization in support of the Rome Statute, and the work and activities of these organizations should never be conditioned to the consent of the territorial states affected by human rights violation or abuses of power. In this respect, the EU, through the European Commission, should continue to create and deepen partnerships and allocate its financial support for global civil society campaigns to the extent possible under the new NDICI 2021-2027. It cannot be stressed enough how indispensable is the role of organizations like Parliamentarians for Global Action in the efforts to achieve a universal ratification, and it should not be overlooked nor taken for granted. Therefore, in this occasion, I would like to send a message to all the 27 ICC states parties that are members of the EU to encourage them to work together to pressure the European Commission to resume its direct support to civil society and NGOs to achieve this important fundamental goal. With these feelings, I would like to send my deepest appreciation to all the colleagues and the speakers today, with the auspices for an interesting and fruitful debate, and with a hope where as soon as the health situation will allow us to meet again in person, to continue together, hand by hand, our strong commitment for the fight against impunity, for a real accountability, and for finally having universal ratification of the Statute of Rome. Thank you very much, and see you soon.
Thank you, Honorable Fabio Massimo Castaldo. I think it was very important that the Vice President of the European Parliament highlighted so many opportunities for the European Union and the European Parliament to create partnership in the Pacific Island states, in certain Latin American countries that are not yet parties, in the Caribbean, of course. And I want to add here Africa, because under the agreement between the European Union and the African states, you have an ICC clause that is now being renegotiated under the revised Cotonou agreement. And this is a powerful incentive for countries like, for example, Guinea-Bissau, who could not participate today. We received apologies from Minister of Foreign Affairs Susi Barbosa, who's campaigning for Guinea-Bissau to be the next president of the ECOWAS, and from our member Honorable Vieira, who's mourning the loss of her mother, of his mother, unfortunately, and they couldn't join us today, but they reaffirmed their commitment to visit the ICC and The Hague as soon as the coronavirus restrictions will allow. And Guinea-Bissau, like other African states, could benefit also from the EU support in the framework of the Cotonou Agreement. So having the European Parliament on our side is very important, has been historically very important for the PGA ICC campaign since 1999. Let me then open the floor for some remarks or comments by our participants. Feel free to pose questions to our speakers or to our experts from civil society. The meeting is going to be recorded, so to a certain extent, of course, we are discussing matters that are in the public domain, but I think universality has been a major priority, but the results have been rather modest due to the fact that we reached a quota of 124 states, with Burundi and with Philippines 125 ratifications, and then now 123 after the 2 withdrawals. And the other member states of the United Nations are countries with a lot of problems. In order to ratify, they need to resolve either political or constitutional or matters that pertain to really the risk of maybe having some of their nationals being accused before the court. I'm referring, of course, to certain regimes like Belarus or Eritrea or the North Korean regime and so on. So there are, of course, these states that are scared by the ICC, correctly so, because the ICC is not a paper tiger, it's a real court of justice. But there is also, in PGA, we understood that there is about 30 to 40 countries that are democratic or quasi-democratic or in transition, and they could be amenable to the consideration of ratification of the Rome Statute. Of course, with different degrees of difficulty and problems that are affecting their democratic status. I don't know if there is any participant want to wish to take the floor at this stage for any comment, question, remark. Maybe if I can ask the president of the court if he has some thoughts to share with us before we go towards the conclusions of the meeting. Oh, I see Honorable Pat.
Thank
Honorable
you.
Pat.
Okay, then give the floor to the discussants first. Thanks.
Of course. And Honorable Patto, please. Your surname is also inspiring because, as you know, Patto in Italian means treaty. So we are there to learn from you about the universality of this treaty.
Thank you, David, and thank you, Honorable Piotr. My question is, I think on the subject of universality, in a time of a political crisis, an economic crisis, and now a health crisis, I think that the general public often sways towards the more conservative. It is the better of the evil they know than the one that they don't. And that is quite scary also in the Malaysian narrative, because we recently had a state election, and in spite of the abuses of power, corruptions, and high-profile cases involving ministers, ex-ministers, and civil servants in very high places, the public seemed to have given the vote back to the government before this. That was the root cause of the disastrous situation that we are in today, which makes me think, how do we bring about these conversations, particularly something on the Rome Statute that is very sensitive, very easily emotionally triggered, to make it relevant and important when people are, you have sort of a siege mentality at this point in time with the pandemic, with the economic crisis, and in Malaysia with the political crisis. What are your thoughts on this?
Thank you, Honorable. Well, I think I would invite also your colleagues and the hosts of the meeting to take the floor. I think these crises and the pandemic restrictions and so on are posing an extra challenge to put in the national agenda of decision makers a matter like ratifying the International Criminal Court Statute. As every other international affairs issue, it is seen as secondary to the pandemic or to the matters immediately connected, like the economic crisis, like the measures to be undertaken to resolve matters that may happen tomorrow or after tomorrow. But maybe the argument to be used here, and you have made use of them, I have understood, is that we have seen how leaving the impunity to prevail can destroy even an entire democratic order. Look at what's happening now to the former leader of Myanmar. When she was in power, she would not be able to fight impunity for the alleged crimes against the Rohingya minority. Now that she had won the elections, she has been unlawfully detained and now politically, she's under politically motivated sentencing, as we seen yesterday and the other day. So I think impunity can create the conditions for further measures that may repress democratic principles, democratic societies, and that could make the sort of emergency status stemming from the pandemic even worse than the one that we have today. So in other words, the link is also there, that it's even more urgent for states to ratify the Rome Statute in this critical situation. But you're definitely right that for parliamentarians, it's much more difficult to put this agenda item on the floor. And even for members of government, it is not as, it was already difficult, but now it's even more difficult. I don't know if I see the ambassador of Korea noting. Yes.
Maybe I have another question. Have we in the past engaged with friends from the media? Because whether it is an idea that stems from the opposition, or if it is a government that feels that, okay, this is probably the time we want to do something, whatever the reason behind it, whether in the Malaysian context, there's a memorandum of understanding between the opposition and the government now, signed with a few items stated that we will amend the federal constitution and we will introduce anti-hopping laws. We will move forward on allowing 18-year-olds to vote, and also to give equal allocations for development, for infrastructure in all, for all members of parliament, regardless of whether you're opposition or independent. But my concern is always on how the media would then report this, because that is where the public get this information. Now, I can do only so much to reach out to my constituents, to talk to them about the Rome Statute, which they really won't care about because it's not a bread and butter issue. But when the media says something like this could drag the king to court, then there's a huge public uproar and an unhappiness and very emotionally charged sentiment. Oh, how could you do this to the king, and etc., etc. And then there's always the question of, oh, but Israel didn't ratify the Rome Statute, neither did America, neither did some of these, you know, giant countries. So Malaysia is not going to lose out if we don't ratify the Rome Statute. And that often depends on how the media narrates the story. And the way they do it can either, there's only two ways it can go. One, that it is an article to educate the public and say, yes, the government is doing enough to take care of the welfare of the people, put food on the table during the crisis, etc., and the lockdown, and to ensure that everyone is vaccinated. But also on an international front, the government is also doing this because it is important. Or will it just be solely talking about the Rome Statute, which will make the man on the street or the woman on the street say, oh, what about us? You know, so I wonder if we could have a session just for friends of the media, you know, whether we can reach out to media councils and National Union of Journalists to see how they can be partners with us.
Well, if I can mention the experience of Ukraine, but Alexandra and Honorable Bardina can be much more eloquent than me. I remember every time we organized a meeting in Kiev, there was the Ukraine Media Center, which was hosting a press conference. And I realized that these had a huge impact. And of course, the civil society on the ground and the members of the parliament on the ground were able to do much more on a regular basis. So at the end of the day, I think it really depends on the way we are able to have an impact on the media. Clearly, in your country, the media has been manipulated by those who use the ICC ratification as a means to subvert the democratically elected government, and you ended up anyway with a backdoor government. Now you have a national unity agreement. So I think maybe now it's the time to rebuild the foundations for proper communications. But I don't know if, Alexandra, you want to say something on the importance of the media, because in Ukraine, you have done an enormous work.
Very briefly, the war which Russia started against Ukraine has different dimensions, and informational dimension is one of them. In Russia itself, we see how it's important to have independent media in the country, because when Russia, and I maybe better to say Kremlin regime, liquidated all independent media and labeled them as a foreign agent, they can control the behavior of population. And even the head of the Russian army, Gerasimov, told that information is much more effective in arms than arms itself. So for us, as for Nation in Transit, it's very important to have freedom of speech in Ukraine, freedom of expression, and to build in the different kind of independent media which focused on different topics. And it's a real challenge. Unfortunately, we have complicated situation, but everything we can compare with Yanukovych regime. The revolution of dignity outlined the path, the good vector, and we are slowly but moving on this path.
Thank you, Alexandra. And I think when Honorable Patto refers to the fact that certain major powers are not parties to the ICC, well, the answer can also be that, for example, the United States, after 40 years from the adoption of the Genocide Convention, they finally ratified. So, you know, it takes more time for those who have larger armies and so on, but eventually they do so. And secondly, coming back to Ukraine, I have read the new strategic partnership agreement between the United States and Ukraine, and there is an Article 8 on accountability for war crimes. So even in a bilateral document, the country, the major superpower that is not yet a state party, yet it's very committed to the idea of accountability, especially we have seen it in the with the new administration. So I think that all these elements are aligning towards reopening the doors for universality. And I don't know if any other member of the parliament would like to speak at this stage. Honorable Brown Burke.
Sure, thank you. I just wanted to thank Honorable Patto for the points that you raised, because I believe that they are really very important, especially where we are today. I also believe that what we have found is that sometimes we really have to sometimes we have an agenda in Parliament and we are having a discussion amongst ourselves, and we have not fully engaged the public with us. And I agree that often the media or members of the media are certainly an important nexus between the discussions we're having, real life experiences, the bread and butter issues of our people, and also as part of the global family. I know that when superpowers take a position, sometimes it influences the position that we take as well. But I agree with you, David, that where we are going now in the world, this idea of being a sovereign state is really taking center stage. And I believe the trick is to kind of find the connection between what some might see as a purely international issue with the local issues, you know. So for Jamaica, whether it is so remote, but there's the issue of reparation, you know, that could be tied into that. And how do you link that, you know, as something that we would have an interest in? And so I believe, as with so many of our global commitments, we have to localize them and get individuals in the country to understand what could be a possible nexus between that international, almost abstract discussion and our own reality.
Wonderful. And Honorable, the board member of the Trust Fund for Victims dealing with reparations, who has been just re-elected, is the former president of PGA from the Dominican Republic, Minu Tavares Mirabal. And so we should work together with her using the reparation angle to create ownership among your colleagues, parliamentarians from a sister country like Dominican Republic.
Absolutely, absolutely.
Fantastic. Honorable Judge Ofmansky, please, you are there to enlighten us on the way forward.
Thank you, David. Thank you very much to all of you for your presentations, your observations. It's extremely interesting, and I'm extremely honored to be here and to hear this discussion. I totally agree that in the aspect, in the context of the universality, there are different types of targets. There are indeed the anti-democratic regimes, and it's simply no sense to start a discussion about them for a reason given by you. There are superpowers. There is the strictly political basic discussion, and this is very difficult. But these arguments related to US, Russia, China are well known. But there is something in between. There's, as you correctly observe, 30 or 40 states, countries that potentially could join, and we still hope that it happens in the future. And here I would like, there of course the different reasons in different countries, and we see it also on the basis of what we heard today. There's a different situation in my neighbor country, Ukraine. There's the different situation in Jamaica. Of course, there are differences, but I would like to underline one basically common factor, which is I think extremely important. It was also underlined in the discussion, which is the lack of information. It is simply the lack of information. And on different levels, of course, this is the information about the parliamentarians, about the people who are responsible, involved in the decision-making process. And I think we should never stop to inform about the consequences of the ratification and the concept of the complementarity in the context of the lack of retroactivity, which is really very important factor. But it may be even more important, but it is relevant to the democratic countries only, is the aspect of the information through media. It's really true, because governments simply take into account how the society reacts on the actions, and this is fully understandable. It is how democracy works, and therefore I think the most important thing is just to try to broaden the activity of the national activities, approach national media to do something in this regard. Of course, we have our website, but our website is not so influenced. It has not influence on people in Jamaica, I think. It was simple an example, but it is for you the task just to share information, what we do, how we work, and how the country and the society can benefit from for this step to be undertaken. And it would be my advice. Of course, there are more factors to be discussed, but I understand we have not enough to go into all this aspect. Anyway, thank you very much for this wonderful initiative, David. Thank you very much for ambassadors from Netherlands and Korea, and thank you for all of you for sharing this really very interesting and very important thoughts during this discussion. Thank you once again.
Thank you, Mr. President. I think that the way forward is rather clear, is that there is no one fit for all solutions to the problem. Each country situation must be analyzed according to the needs to create ownership. But as you said, Mr. President, we need to convey the message that the national interest to join is equal to the interest of humanity to protect civilians and other vulnerable persons from genocide, crimes against humanity, war crimes, and the crime of aggression. It's a common interest, and it's also a self-interest. It's the same, it's one and the same thing. And I think it's one of the few items where being generous and in solidarity, or using the word solidarność from your political history, Mr. President, it's equal to being egoist and being wanting to protect oneself, because we don't want these crimes to be targeting our parliamentarians who are in the opposition. We have so many in jail, unfortunately, including the former Minister of Justice of the Philippines, who's fighting like a lion for the Philippines to re-ratify it. She's in jail for more than 4 years, Senator Leila de Lima, a prominent human rights activist, but an opponent to Mr. Duterte. So we have a duty together to unite forces and support the ICC and the Rome Statute system. There are other countries like Tuvalu and Guinea-Bissau where we see the possibility of ratification in the mid or even short term. And I think with this positive note, I invite everyone to remain in touch with us, with each other, with the presidency of the court, with the facilitation by the Netherlands and Korea of the ASP, with other partners like the European Union, and whoever is engaged on promoting the universality of the Rome Statute. So I wish to thank everyone and see you soon at the ASP or virtually at the next possible online meeting. Thank you very much.